All right. Can counsel on the Aidan Kearney matter identify themselves for the record?
Good afternoon, Your Honor. Kenneth Miller for the Commonwealth.
Okay.
Hello, Your Honor. Timothy Bradle on behalf of Aidan Kearney.
Okay, thank you.
Your Honor, this is my client, Aidan Kearney.
Thank you. Thank you very much. Since our last meeting, received the Commonwealth's reply and opposition to the defendant's petition. I received a supplemental memo from counsel for Mr. Kearney, and I received a supplemental affidavit from Mr. Kearney. Should I have received any other documents?
That's it, Your Honor.
No,
Those
Your
are
Honor.
hard copies of those documents before you.
All right. The supplemental affidavit of Aidan Kearney contains various links to things which are electronic
Yes.
and not in front of the court. I don't take cases that way. I don't take exhibits that way. I can't because things are fluid on the internet and we need to make a record of anything that's submitted to the court. So if you have these YouTube videos or something on a disc, I'm happy to look at them. But I am not going to look at things that are on the website here today, gone tomorrow, or anything like that. I'm not suggesting anything would be taken down, but the record has to be clear for an appellate court to review. And so I do not have a thumb drive or anything else with any of these links or items to which there is a link in the supplemental affidavit. I know you purported to file something electronically, but I cannot take exhibits to a document electronically. Do you have them in a form that I can take and make a part of the record?
Sure, Judge. I'd be happy to put them on a thumb drive and we can make an exhibit.
Okay, when can you get those to me?
Can do that. I don't think today is going to be good, but I can supply it tomorrow morning if you like.
Okay, we'll take those as an exhibit. Just make sure they cross-reference the paragraphs in the affidavit. So supplemental affidavit, paragraph 2, for example, references a YouTube video. If you want me to watch that video, you've got to give it to me on a disc and it's got to say paragraph 2, okay?
Happy to do it.
Something like that.
No problem.
Okay, thank you. All right. Now, I've read all the papers that everybody filed. Thank you for the effort. I'll hear from Mr. Bradle first, and then I'll hear from Mr. Mello.
Thank you very much, Your Honor. Your Honor, this is not your everyday bail review. Your Honor sits in full de novo review of this ruling, and this is not the kind of case that a stay-away order ×8 against a journalist should stand. The Commonwealth sort of looks askance at the First Amendment arguments here and wants to just treat this as a sort of a regular case. This is not a regular case, Your Honor. This is an unprecedented prosecution. The Commonwealth, I think, is sort of lost in the fog of war on the Karen Reed case. And as a result of that, they've been criticized, they've been taken to the woodshed, if you will, by Aidan Kearney. And the very same squad of detectives that have been investigating that case, that have been roundly criticized, exposed, investigated by Mr. Kearney, they themselves have used the mechanism of the state to bring these charges. These charges are so unprecedented, Your Honor, that there's not only a First Amendment barrier to these charges, there's a due process barrier to these charges. The government, this is in my supplemental memorandum, Your Honor, the government cannot take long-standing behavior that is...
So this is a new argument that the Commonwealth hasn't been able to address. You filed an initial memorandum. It raised First Amendment issues. Then you filed a supplemental argument, supplemental memo concurrent with the Commonwealth's filing. They addressed the First Amendment issue in their brief, but they didn't have the benefit of any due process argument. Now you're advancing a separate argument, a due process argument,
Your
right?
Honor, Mr. Kearney has a 100% right to remain silent in this case.
Yeah, you don't have to advance any arguments. But if you are going to advance arguments which are complicated, sophisticated, and out of the ordinary, which is what you're arguing, you have to at least give the opposing side the opportunity to address the arguments. The arguments were framed by you under the First Amendment. I wanted the parties to address those in writing. Mr. Mello addressed those in writing. You also, to some extent, addressed them in writing, particularly Mr. Kearney's affidavit addresses them. But then you raised an entirely different argument in your supplemental filing, and I'll hear you now on it, but Mr. Mello may want an opportunity to address that new argument.
I have no problem with that, Your Honor.
Okay.
My thought on this, Judge, is just that, if the government is going to explore into unknown worlds of prosecution, that they ought to have their arguments together as to why it fits under the Constitution. We're trying to defend against the government here. They have the burden to establish their case. They have the burden to, especially where they're going to try to create an entirely new realm of liability that involves fundamental rights. I would think they would have their ducks in a row to be able to defend it.
So let's talk about the due process argument. I think I understand your First Amendment argument.
Sure. Thank you,
Okay,
Your Honor.
let's talk about the due process argument. You say that your client doesn't know what's off limits.
That's
Right?
correct, Judge. No one knows it's off limits. And I'll show you this in the thumb drive. There's hundreds of examples of reporters never been prosecuted or criticized even for showing up at people's sporting events, showing up at people's houses, taking video, asking tough questions. Those are the people that need the protection, Your Honor. The government, again, in the fog of war on the Karen Reed case, that's why they're doing this, because they're the ones that are getting exposed. There's never been a prosecution like this, Your Honor, so there can't be any fair notice to this. This is behavior that is flashed across news screens all the time. Every journalist in this room probably has employed sharp tactics from time to time, getting in people's faces, showing up in people's driveways. It's not witness intimidation. And
You think a journalist can call up a witness and say, it's Turtle Boy from them Advantage Boys, bang, 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 bang. We'll fuck any of you dogs up. You think any journalist can call up a witness and say that and not have it be construed as witness intimidation or a threat? You think that's the law?
Yes, I do, Your Honor. Political hyperbole is protected. There was a case in the 60s, Judge, where someone that was against the draft said that if you put a gun in my hand, the first person I'm going to go after is Lyndon B. Johnson, and the Supreme Court held that was political hyperbole. It is protected, Your Honor. It's very broad. And again, polite society might not like it, but frankly, at this point, Judge, I'm tired of talking about, gee whiz, we don't like this behavior, but gee whiz, I wouldn't do it, you wouldn't do it. Let's just talk about the First Amendment here. Let's talk about due process. Let's talk about the government's motives in doing this, which are to protect themselves from being exposed as in an investigation that stinks. That's what's going on here, Judge. This isn't someone who is spewing hate. This isn't the KKK in Brandenburg. This isn't the Nazis in Skokie. This is a journalist doing good work, exposing corruption, exposing the government. So it's not even people spewing hate speech, which is all protected. He's speaking out on matters of public concern. And in matters of public concern, as you know, I know you know this, Your Honor, the protection of the First Amendment is at its zenith. So back to the due process argument, Your Honor, there's nowhere that any of this behavior has ever been prosecuted. And the cases that are cited by the government are all an opposite. They involve family members of defendants intimidating people in courthouses. The government cites Brandenburg, which protects the KKK. The government talks about harassment a lot.
So you're backing into the First Amendment. Question is, what's the due process challenge?
The due process challenge, judges, there's no fair notice that this was a crime. That's it. It's cited in there all over the place.
Okay. All right, I'll hear from Mr. Mello.
Thank you, Your Honor.
Good afternoon, Your Honor.
Mr. Mello, go ahead.
Record, the fair notice that this was a crime is contained in Mass General Laws, Chapter 268, Sections 13A and 13B. It's extremely clear that the general court has prohibited the acts which would interfere with witnesses in criminal matters and in civil matters as well, and has prohibited, for instance, in the instance of the rolling road rallies that Your Honor referenced earlier, has prohibited that type of conduct. You cannot picket or protest outside of a witness's home with the purpose of, intimidating or influencing them in any way. Chapter 268, Section 13B, which is set forth in our memorandum, and I'm sure Your Honor was certainly aware of all of the criteria set forth there, lists, there's a long list of people, individuals described, including family members of witnesses, and they don't even have to be witnesses, Judge, they could be potential witnesses. The statute's pretty clear that cannot be or protected from intimidation. This is not a First Amendment case, Your Honor. The defendant has stated alternatively on many of his blogs and his other internet sites that he is a journalist, an activist, and a satirist. The general court, in setting forth the language under Section 13B, clearly was looking to prohibit things such as walking up to someone's front door or a storm door with a glass front is closed, but the interior door is open, from walking up to that witness's door and videotaping the interior of the house. The general court clearly intended to prohibit someone from attending the sports games of children of witnesses in cases. It clearly intended to prohibit an individual from chasing a state trooper across the street outside of this court with a bullhorn. This is not journalism, Judge. This is activism. This is whatever you may call it. And certainly the government is not looking to define how journalists should conduct themselves. But when you look at it, you can see that this is not what they're defending for. They're not defending journalism.
We can talk around the edges about whether things are or aren't journalism, and we can talk about where the line is. But clearly, Mr. Kearney is reporting from his perspective on things related to the Reed case and putting things on the website and blogging about it. One can talk about the tone, one can talk about the content, but clearly he is reporting on matters of public interest, not in a way sensitive or sympathetic to the Commonwealth's position. But clearly there's a First Amendment interest in at least some of his actions. The district court judge issued an order saying that the defendant had to stay away from 7 different individuals and lists those 7 individuals, but didn't articulate a distance from those individuals, which creates an ambiguity for Mr. Kearney about what he can and can't do or where he can and can't go when those individuals are in the vicinity. That seems to be an ambiguity that does limit what he can do and seems like something the court should correct.
Your Honor,
What do you say to that? So the judge wrote, he put a check mark next to stay, and then it says distance, and then there's a blank line, and then it says away from, and he wrote in names. So Mr. Kearney reasonably would not know how far he has to stay away from those individuals. What do you say to that?
the Commonwealth considered that in its conclusion, in its memorandum, where the Commonwealth further requests that the Superior Court impose any further conditions of bail on the defendant as the court may deem appropriate. That was intended to include such things as a distance, a stay-away distance. Given the fact that the defendant has gone so far as to use a bullhorn and has shown up at sporting events, school sporting events, and has gotten thrown out of those events because of his actions, I would ask Your Honor to set a 500-foot distance from which you can no longer approach these individuals.
No, we're not talking about the no contact order, okay? If Mr. Kearney were to get on a bullhorn and call out to witnesses or call out about witnesses in a way that would be direct or indirect contact, that would be problematic. But I'm talking about where he can go when those individuals are nearby. And 500 feet is a distance that, frankly, never seen a court set. It's a pretty long distance. So I'm just trying to understand the reasons for a distance that you would suggest.
Your Honor, the reason for that distance is because in these instances, if he was within 500 feet on a bullhorn, he would barely be audible at that distance. And I'll grant you, Judge, that's subjective. But it seems to be reasonable because certainly within 100 yards, he can well be heard if he's advocating for one cause or another within the distance of these witnesses. Nonetheless, Your Honor referenced his posts on social media. The government would be the first to come before the court and advocate for the right of anyone to post on social media. And however, the limitations there have been well established by law for decades and perhaps centuries in the United States. A journalist, by virtue of one being called a journalist, that does not confer upon an individual the right to break the law. It's not a license. You have certain freedoms that you can demand be observed, but those freedoms do not extend to harassing witnesses, harassing their children, etc. Your Honor received as a supplement to the memorandum a report or statement from Detective Lieutenant Tully.
Hold on one second. Let me just see. Go ahead.
And there are that's only a small number of some of the incidents that have occurred by virtue of actions of the defendant. This particular individual approaches people in a way that where he says, "I'm not a threat to you. I'm not going to cause you any harm," but his actions are contrary to his words in many cases. He's called people and indicated, in one instance to one of the witnesses, has advocated on his pages, his web pages, has advocated for people to call the employer or to post on the employer's website, clearly intending to cause some economic harm to that witness and jeopardize her job, hoping that, I would say by extension, you could assume that they would hope that the employer would come down on that particular witness for having brought that type of notoriety to the company. There are other instances where he's advocated for people to go to the business of an individual witness and order things and seemingly not pay for them. Those have all been advocated for by this defendant. And that's the economic harm that a witness would suffer. In one particular instance, one witness who owns a pizza shop in Canton has reported a marked increase in the number of orders called in that were not picked up. And that's because this defendant has advocated for that. There are other instances where he has approached people and stated online, life as you know it has changed. You won't be able to go anywhere without being photographed or followed. We know where you've been. There are instances where he's conspired.
I appreciate that. I read the underlying documents that were filed in support of the complaint with respect to the 9 cases. Let me ask you this too. Mr. Kearney objects to the stay away, no contact because it says he will not be able to be in the same place as the witnesses / victims, okay, who were named in the in the 9 counts in the Stoughton District Court. Do you agree that he should be allowed to attend proceedings in the Reed case here to the extent he is conducting reasonable journalism?
Yes.
Okay, so we should we should allow him to attend those hearings, and that should be made clear in whatever conditions are set.
And Commonwealth would agree to that, Judge.
Okay,
Yes.
all right. So that would be an exception to, if I were to select 500 feet, to the 500-foot stay away condition so that he could attend court proceedings.
Yes, Your Honor.
Okay, if I adopted the 500. Okay. Anything else you want to add?
No, Judge, other than for the fact that in this case, you know, and I don't mean to repeat myself, the representation that this is in any way stifling to journalistic activity does not carry any weight, Your Honor. There are 2 statutes on the books, particularly that have been violated more than anything else, and that is the statute of harassing and intimidating witnesses and their family members, as well as protesting or organizing, et cetera, around their homes. And that's as precluded by 13A. And you can't hide behind the shield of a journalist to break the law. And an example I have thought of is, if this particular defendant were following a story, had an allegation that a bank in the community was passing counterfeit currency, would not give him the right to break into that bank and to break into the vault to check for himself. There's a law in the books that precludes that or prohibits that. Same here with intimidating witnesses, Your Honor. Same here with protesting in front of their homes.
Okay.
Thank you, Judge.
I'm going to get something from Mr. Bradel by tomorrow, plus or minus. And I will take the matter under advisement. It'll take me a little while to take a look at whatever Mr. Bradel submits tomorrow, but I'll take the matter under advisement. Okay?
Your Honor, may I address just a couple of things raised by the Commonwealth?
Sure. Mr. Miller, you can have a seat if you wish.
Thank you very much, Your Honor. Just briefly, Judge, I don't want to take too much time.
I do have one point, Judge.
Sure, go ahead.
My last point, if Your Honor is going to accept additional evidence.
No, the only additional evidence I'm going to accept is a copy of whatever is linked to in Mr. Kearney's supplemental affidavit. I can't remember if it's called the supplemental affidavit.
Okay, what I was going to state to the court is, if Your Honor like, we were prepared at our last session to show the court some video clips that would exhibit the type of conduct that we believe is a violation of the law. If Your Honor would require us to do so, we can.
I've read the documents. I don't require it. If you have video clips that you want to submit to me, you could have submitted them to me already. No. I'm happy if there's no objection to take them at the same time I take something from Mr. Bradel. Mr. Bradel, what's your view on that?
No problem, Your Honor.
Okay, if you want to submit some video clips for me to watch, you can submit them to me by close of business tomorrow as well.
Thank you.
Okay? Okay, Mr. Bradel, go ahead.
Thank you very much, Your Honor. I wanted to address the quote that you brought up that sort of out of context sounds like it's something that might trouble the court. And what was really going on there, Judge, is that Mr. Kearney was calling a witness and satirizing his threatening video that Mr. Kearney had seen. And Mr. Kearney was mocking that and repeating that back to him, what was said by the witness, roughly stated. And he then shifted in that conversation into leaving a message about the Reed case, asking journalistic questions about the case. So that's what's going on there. There was no attempt to threaten or violate the witness intimidation statute by satirizing the witness's own statements back to him. So
What the intent was will be for a jury to determine. I'm faced with the statements, okay?
Sure. And I just wanted to give context in terms of there's a number of factual disputes about what's going on here. The government,
I'm sure there are.
And the government says that he videotaped the interior of witness homes without their permission. Judge, walking up to someone's door, knocking on the door while the camera's rolling happens all the time in journalism. And if the door's open, you're going to see inside the house. People can put up a no trespassing sign. people can keep their door shut. But if someone walks up to the door, if a journalist walks up to the door with news cameras without any no trespassing signs, that's protected by the First Amendment. If something inside the house that's open to plain view from the street gets videotaped, that's not a crime. That's not witness intimidation. Protected by the First Amendment. This is a series of things that the government cites, just flatly cites behavior and expects a court to look at it and go, yup, that's witness intimidation. It's not witness intimidation. It doesn't satisfy the First Amendment. The standards in O'Brien versus Borowski for harassment, Your Honor, they have to apply here. They can't not apply. So I'm asking you to apply those. And whenever you look at any of these factual nuggets that the government wants to say is witness intimidation, they abjectly fail under O'Brien v. Borowski, under the First Amendment, and they should not be credited as witness intimidation. And again, this goes back to the merits of the case.
Harassment is one provision of the witness intimidation statute.
Yes.
But willfully threatening or attempting or causing physical, emotional, or economic injury to witnesses is another element of the witness intimidation statute.
Yes.
When you publicize somebody who is the wife of an investigator's job and say, and you say to my followers, call this job and let them know what you think about her. Or I don't think that's the way it's phrased. I think it's more like, there are these open websites, get at it and post on those websites. I am very much paraphrasing, but that's the sentiment of the conversation that's posted by your client, as I understand it.
Sure.
That is not reporting, that's advocacy. That's encouraging people to do something to another party's economic disadvantage. When you tell my followers to go and call a restaurant and order food and don't go and pick it up and don't pay for it, and that's what happens, that's economic injury. That's it certainly may cause emotional injury too, but it's certainly economic injury, which is an element of the witness intimidation statute separate from harassment. So I don't think you're telling me that first clause of the witness intimidation statute does not apply in a First Amendment context. It sounds to me like what you're arguing is that the actions by your client did not attempt to cause emotional or economic injury. That seems like what you're arguing, but I want to make sure I understand clearly what it is you are arguing.
I appreciate that, Your Honor. That's part of what I'm arguing, absolutely. But the second part of it, Judge, is that if you look at the analogous framework in O'Brien v. Borowski, economic injury is not allowed. Economic injury violates the First Amendment, criminalizing that. You're allowed to boycott. You're allowed to urge people not to do business with someone. You're allowed to say to people, I'm going to sue you and destroy you. You're allowed to do that. That is prohibited under O'Brien v. Borowski in the harassment context there. There's no reason why that shouldn't be applied here, Your Honor.
Okay, so are you aware of any situation where that case's description, that case's ruling in the 258E context was applied to the witness intimidation statute to say that nothing other than what constitutes actionable harassment under 258E can be enjoined or prosecuted or constitute a crime under the witness intimidation statute?
There is no such case, Your Honor, and that's what I'm inviting this court to do. On the merits, looking at the merits of the case in the context of whether collateral order should issue, I ask that you find that it's unconstitutional, that those activities are constitutionally protected by the First Amendment, that you can threaten economic injury to a witness, and it's covered by the First Amendment. Absolutely. That's why the court, in the analogous context in O'Brien v. Borowski, truncated it to threats, fighting words, and the fear can only be applicable to bodily injury or property damage, not economic injury. That's something for a civil court. That's something to be hashed out in the marketplace of ideas. And that's my position on that, Judge. The law there is going to become the law here, and I hope it happens in Dedham. I hope it doesn't have to go to Boston or Washington, D.C. But at some point, I have to urge the court that that's going to be the law here, that these statutes are incredibly overbroad. They inhibit freedom. They inhibit the First Amendment, and they need to be stopped.
Okay.
Thank you, Your Honor.
Thank you. I'll take the matter under advisement. I'll get whatever I get tomorrow, and you get a ruling from me. Okay? Thank you.
Thank you, Your Honor.
That's it, Judge.
State Trooper Michael Proctor contacted the employers of multiple turtle riders. That's what we call our fans. Multiple turtle riders. She contacted their employers and said that they should be fired because they commented negatively about her husband. In return, I wrote about that. I said, here's what this woman did. She is trying to get people fired for speaking out against her husband. In response, people contacted or posted on her company's Facebook page with negative comments about them. So it's okay when she does it. But when other people do it to her, it's suddenly a felony. That is how protected Elizabeth Proctor is, because her husband is a state trooper who I have been criticizing for covering up the murder of John O'Keefe and framing Karen Reed. It's undeniable. The evidence shows it. And because people have the audacity to speak out about Michael Proctor, Elizabeth Proctor has a history of trying to get them fired from their jobs. That is the real story that has not been told to Judge Krupp.
Is 500 feet okay with you?
No, 0 feet is okay with me.
And were there any, back to the Proctor thing, did you urge at all anyone? Did you put the information out? Did you say, I didn't see the clip, did you say contact?
I don't remember the exact thing, but I said I did post about what her employer's name was, since that's what we're doing now. And if people commented on her page or gave them a negative review, that's on them. I didn't leave a negative review on Instrom's Facebook page. If Instrom wants to employ somebody who acts like that and behaves like that, they're free to. But I have a right to inform the public that this woman is doing this behavior and she works for this company over here.
Judge Krupp alluded that this case would eventually be heard by a jury. Did you think it would ever go that far?
I have no idea how the process works. I'm happy to try this in front of a jury, whatever they want to do. I'm not afraid. The facts are on my side. I would love to get these 8 so-called victims or witnesses on the stand and ask them about exactly what they did. And I would like to ask Elizabeth Proctor why she did that, why she contacted people's employers, and why it's not okay when the same thing ends up happening to her.
You've been very supportive of Karen Reed and her family. Have they been supportive of you? Have they reached out to you?
Oh, I've had conversations with the Reed family for sure. Positive conversations.
Thank you.
You're very welcome.
Good job. Tim, you want to add anything?
Any questions? I'll take questions.
So the judge talked about due process and that being originally the argument was based on the First Amendment. And so is he going to want more documentation to back that up? Or?
Yeah, I mean, he's trying to be fair to the Commonwealth. I don't have any problem with that. You know, we're not here to compromise. We're not here to work out a solution. These orders are unconstitutional. They need to be vacated. If they can take a month if they want to find some law in their favor. They're not going to find it. This case, we just kept uncovering theories on why this violates Mr. Kearney's First Amendment rights. You know, it violates his due process rights. The government can't just suddenly decide that everything that all of you folks do every day is now a felony. That's absurd. That's a due process violation. The government has to give fair notice. A reasonably intelligent person has to be able to look at a statute and know what is prohibited and what is not. And there are reams of videos where people stick a microphone in someone's face, and I don't mind, Ted, you're sticking one in my face. But you know, when you're trying to uncover hard stories, hard facts, you have to get tough. And I know a lot of you here, and you know, a lot of you have to get tough, and I've seen it, and it's terrific for uncovering the facts, uncovering the truth. And the only reason Aidan Kearney is the one on the chopping block here is because these prosecutors, these state troopers, they're lost in the fog of the battle here on the Karen Reed case. And Aidan Kearney is uncovering facts that hurt them. And so they used what was at what they had to go after Aidan Kearney. They used the machinery of the state to prosecute him on something that is unprecedented, pure journalism, on something that is tough journalism that is completely covered and protected by the First Amendment. The Supreme Court allows KKK, allows Nazis, allows awful people to spew hate. That's not even what we're doing here. Aidan Kearney is doing good work, is speaking on matters of public concern, is what the Supreme Court calls it, and is acting in such a way that helps society, helps the pursuit of truth. And he's the one that's on the chopping block. It's outrageous. This is a doomed prosecution, whether it ends here in Dedham, whether it ends in Boston at the SJC, or whether it ends in Washington, D.C. This prosecution is doomed. Thank you.
Do you have to submit one more document before he takes the matter under advisement and issues a ruling?
Yeah, we supplied to the court in an electronic filing reams of clips off the internet where reporters, probably some of you in this crowd, are showing up somewhere impolite, showing up somewhere that might raise an eyebrow, showing up in a guy's driveway, asking tough questions, taking an advocacy point of view, and trying to get facts from a witness.
I believe it was your station where a reporter showed up at Rachel Rollins' house and asked her about a road rage incident that I first reported. And Rachel Rollins flipped out on her and yelled, "Get out of my, you have no right to be here." But the reporter did have a right to be there. That's the time-honored tradition of journalism in this country. And what they are trying to do is ban people from being uncomfortable. Protesting is designed to make people uncomfortable. 250 years ago, this coming December, less than 10 miles from here, a bunch of people made the British uncomfortable by throwing a bunch of tea off a ship. And it jump-started a revolution that ended up creating the greatest country in the history of the earth, one in which free speech and free press is protected at all costs. And what they are trying to do right now, what the state is trying to do, what the corrupt Massachusetts police are trying to do, is trying to outlaw that. The same Detective Brian Tully, who signed the reports, Michael Proctor's fraudulent reports, is the one who not only spearheaded this entire investigation and this entire prosecution, he comes to every hearing as well. He is here today. Meanwhile, there is a Ford Edge out there that was parked at 3 a.m. right next to John O'Keefe's body outside of 34 Fairview Road. They are aware of it. It has now been 83 days since they became aware of it. Instead of finding who was driving that Ford Edge, he's in here watching this sham of an injustice take place in this courtroom, which he spearheaded.
Right.
Thank you.
Katie, what effect does